Law is confusing, and news today is basically all just law, so I am here to cut through some of the noise and keep you up to date. Happy Wednesday, everybody. I'm Brian, and this is the morning report for August 6th, 2025. Let's get into it, shall we? Now, after a strong showing on Monday, yesterday wasn't quite as strong a day for the DOJ and the Fed. A couple of kind of weak moves out of the gate. Let's talk about it. First, there is some drama at Voice of America, you guys. Abramowitz v. Lake. We just talked about this a couple of days ago. The judge ordered the government to prove that it is following the law requiring that Voice of America keep operating and doing what it does. So, what did Kari Lake, who's in charge of all that mess, do in response? She fired the director, Michael Abramowitz, the guy who brought the lawsuit. Not an exceptionally smart move, generally. Basically, in order to get rid of Abramowitz, they tried to reassign him to a job as chief management officer, which was a huge demotion and would require him to move to North Carolina. Well, we have laws about that. You don't get to just pretend you didn't fire somebody because you offered them a demotion and they didn't take it, especially not while they're in the middle of suing you. And it just so happens that Mr. Abramowitz can't actually be reassigned without a vote from the Broadcasting Advisory Board, which obviously never happened. But the government called his refusal to accept reassignment quitting and/or fired him for insubordination. They said he failed to meet the executive core qualifications of leading change, which is kind of nonsense. So Mr. Abramowitz is asking the court to step in before the firing becomes final on August 31st. This was a bold move by the government. I'd be amazed if it stands, but I have been amazed before. Okay, what's next? Nemeth-Greenleaf v. OPM. Okay, this is a case where DOJ got access to personal data of government employees and the employees are suing. The plaintiffs say DOJ teams got unauthorized access to sensitive HR and payroll data, everything from social security numbers to bank accounts, in violation of the Privacy Act. The government's reply? There's no harm, no foul, and definitely no standing. They want this case dismissed entirely. And yes, some plaintiffs did have fraudulent credit card charges, but the government says that's not their fault. Because how could you buy a bunch of stuff when all you have are routing numbers and social security numbers? Which technically is true. So the government filed a motion to dismiss yesterday, leaning very hard on a recent Supreme Court case, SSA v. ASME, where the court granted a stay in a nearly identical lawsuit. But there's a problem. Say it with me. That was just a stay. They didn't actually rule on anything substantive. Also, there was no opinion, so we don't know why. No reasoning, no explanation, no argument. Still, DOJ argues that this silent stay should guide the judge here in granting a dismissal, even citing case law about why we should treat Supreme Court meh as something that actually means something. In another bold move by the government here, they're relying on a case that, legally speaking, did not actually say a word. But it's a Hail Mary, I guess. Shoot your shot. Okay, courtroom shuffle time. The feds are going to trade places, and this time they're going to file the complaint themselves. In U.S. v. New York, the federal government is suing New York State over a law that bans sharing DMV records with federal authorities. But New York just dropped a little reminder yesterday in the court's inbox. Hey, by the way, Illinois already dealt with this exact lawsuit and tossed it. See, last week, a judge in the Northern District of Illinois dismissed nearly identical claims. Same federal statute, same constitutional theory, same general vibe. So New York's message is pretty clear. Respectfully, Your Honor, we'd like to skip the part where we pretend this is a new case and skip ahead to the part where you just dismiss it. The judge has not ruled yet, but, we'll keep an eye on it. All right. Let's talk about Coalition of Humane Immigrant Rights v. Noem. Now, this is related to expedited removal policy. Now, look, immigration litigation is kind of a hot mess right now. Some of these cases are about people trying to get in, some are people being taken out, some are people with criminal records, others are folks who were here legally until just a couple of months ago when an executive order kind of yanked the rug out from under them. And they're all tangled up, but they are not the same. So this case is about expedited removal. That's not the same as removal to a third country or border security rules or refugee resettlement. And it's easy to let these all kind of get blended into a smoothie and not separate them into our heads. And I get it. This is complicated. It's so complicated, I'm about to just blow past it because I don't have time to explain all of these differences here. But just try to be a little bit present and think about the differences between these cases when you hear about them. That's all I can ask. Okay. On August 1st, the district court blocked the federal government from using expedited removal on certain migrants who had been paroled into the U.S. at ports of entry. Now, that ruling halted three major DHS policies, and the government is asking the court to hit pause while they appeal. In Tuesday's filing, the Department of Justice argues that court got both the facts and the law wrong. First, they say the court never had jurisdiction to hear this challenge at all because a 60-day filing deadline expired back in 1997 when the original rule was issued. I am always a little suspicious when the government says the court has no jurisdiction to hear a challenge at all. We don't let anybody do anything in this country without some sort of check on their power, right? That's sort of the whole basis of the United States. But, okay. Second point, the government says that the court misread the law. Okay, that may be true. They said, parole doesn't change a migrant's legal status. They're still arriving aliens and subject to removal. Basically, we let them in. We let them physically walk across the border for now while we consider their case, but they never were totally allowed into the country. And that may be true. We'll see. Parole is going to come up in a lot of these cases in the near future, so I would probably start thinking about it a little bit. It's going to get talked about a lot more. Keep an eye out for these discussions. And just try to listen for the differences between some of these cases, and even though they're on the same subjects. I know it's a mess. I will do my best to help, I promise. All right, last thing, I'm not even going to put this up in a graphic, but we have two more cases going to appeal. American Federation of Government Employees v. Trump, which is a USAID case I talked about yesterday, and Coalition of Humane Immigrant Rights v. Noem, the one I just talked about. Both filed notices for appeal last night, so keep an eye on those, okay? All right, that is your Wednesday morning report on the past day in the federal courts. Please follow me for more information about law and government. Let me know how you feel about these decisions and actions by the court and government and the plaintiffs. How do you think the court should decide on some of these cases? And if you know somebody who'd like this, please share it. Otherwise, keep watching, everybody. I'll keep working on these. Thanks a lot. Have a great Wednesday.